with us. Oh, very good. We would like to have a platform for ongoing collaboration and encouraging peer-to-peer knowledge sharing. And why not have an annual mediation conference dedicated just for mediation in the continent? And if you would like, we would be very, very happy if you would join us at the Africa Mediation Network. Just type those words into LinkedIn and you will be automatically admitted to the network. So how did we do that research? So we started by a desk research for the 54 African countries, identifying existing mediation schemes, be them private or public. We conducted stakeholder interviews, and then we developed a questionnaire that was translated into Arabic, French, and English. So in the questionnaire, we wanted at first very basic information, because if you want to have a list that eases access to mediation centers, we needed to get the center details, the name, the address, the website, who to contact, etc. And then we went into disputes. So what were the types of disputes going before those centers? What's the volume? And what's the referral? Do parties voluntarily come? Are they referred by court or another program? So, and also if the records are automated in the centers. And finally, we wanted to study the mediation and mediator data analysis. So what is the type of mediation? Is it evaluative? Is it facilitative? Is it another form? And if there were mediation rules for specific mediation programs, what's the interplay and the relationship between courts and mediation, and who are the mediators? And our tools were, especially with the pandemic, emails, Facebook, LinkedIn messages, Zoom interviews, and consultations. And it's we had no funding, so this has been done on each member's private time. And what we achieved so far is we received responses from 13 countries, and we put the answers into Excel so that we could analyze and see what would be the next steps for the project. And there are 4 detailed reports covering different countries, with others still under preparation. So before I go into the findings, I want to warn you that we're still here. We're very much into the tip of the iceberg. And so anything you would hear here, please take it with a grain of salt. We haven't heard from many other countries, we only have data from 13. And with different data coming from new countries or from new centers within the country, the tips of the scale can very much change. We have actually a good representation from the respondent countries from North, East, West, and Central Africa, as you can see on the map. With 7 countries being from a common law system, 4 from common law, and 2 from common and civil. And that might be interesting later on when we do delve deeper into the analysis to see what are the different terms depending on the legal system. And we have identified 44 mediation centers or programs in Africa. Mostly they are court annexed or court connected, followed by private initiatives, and they can be either profit or non-profit, and then government initiatives. And back to when mediation became a formal trend, following formal mediation training. So we know that actually the trend started in 2000. Before 2000, we only had 2 centers working in mediation, but after 2000 we have sort of like regular establishment or initiation of new mediation programs, as you could see on the graph. And one of the main indicators to see whether mediation is actually working is the case volume. Are people using mediation? Are people filing mediation requests? And here we measure the intake and initiation of mediation. And for intake, we mean that a party has filed a request for mediation, or the case was referred by court or by a program to a mediation center. And initiation, we mean by that the process had actually started. So across Africa, we have a total in the past 5 years of slightly above 200,000 cases. And the initiated, and I noticed that there is a mistake on the graph, is actually slightly also above 195,000 cases, which is a decent number given that we only have data from 13 countries and not from all programs across the continent. And you will see on the graph that there is an interesting variety of numbers, with some less than 1,000, with some a bit more, and we go a bit for the 8,000, 13,000, and then we jump into 150,000. So the initial conclusion that we could draw from that research is that the strong uptake follows the government backing of a mediation program. If it only relies on private efforts, this is where you see the numbers are way less than those backed up by government. And the settlement rate across Africa is 54%, again, with varying rates across the countries. And it's when we analyze mediation data, it is actually crucial not to link the success of a program to the settlement rate. It is still a very important indicator, but it has to be taken with a grain of salt. For example, some US studies have shown that when programs measure their success based on the settlement rate, mediators tend to push party into settlement, which isn't really a high quality mediation process when the mediator feels pressured to have a successful case, and therefore pushing the parties and not giving them enough opportunity to be heard or expressing themselves or exploring all the issues in dispute. And sometimes a high settlement is driven by a strong judiciary where the parties know that a quick decision will be issued and enforced. But then again, it doesn't say much about the quality of mediation. So these are questions that we aim to explore further. And just a final note also on the settlement rate and why we shouldn't always take it as the most important indicator is that some mediation styles, such as transformative or narrative mediation, settlement is never the goal. It's actually the transformation of the relationship, the healing between the parties that is the main goal, and settlement can be a byproduct. And we also were asking what are the most important, or not really most important, the main type of cases filed across Africa. And we see the commercial cases taking the lead, followed by family cases, then land, employment, and housing. And the mediation style was mostly facilitative across the continent, which personally for me was a bit surprising because from the literature I've been reading and from the practice in Egypt, I know there is a more interest in evaluative or more traditionally based forms of mediation. So that's also a question that we would like to dig deeper into. And good news for all lawyers attending here, mediation doesn't mean any less business for you, because as you can see from the graph, most countries have reported a high level of representation of lawyers. There is no denial, actually, that lawyers can have an effective role in mediation so long as they let the parties express, because as we've seen in many cases and in many articles, an apology can be the catalyst for settling a multi-million-dollar dispute. And that can only happen if the parties are attending. And a frequently asked question about mediation is, when is the optimal timing to resort to mediation? And here we wanted to measure the practice across the continent. We see that mostly the cases either go to mediation before filing the court case or within 6 months from the court case being filed. Past that 6 month time, there isn't that many cases being referred to mediation. So what are our next steps? We still want to get responses from more countries and more institutions within the countries. We want to translate laws and regulations pertaining to mediation in Africa, publish a comprehensive research on mediation in Africa, and have a companion website where you can have periodic updates and have data accessible on different countries. And as I said earlier, have an annual conference on mediation in Africa. So how can you help us? If you're a policymaker, a professor, a lawyer, arbitrator, mediator, or anyone out there, just please contact us at hiroaragaki@rls.edu. You will have a copy of the presentation where you can get the email from, and we will send you a copy of our questionnaire. And if you are a development agency, we'd really welcome funding from you. And thank you, and like to hear back from you. Hello?
Hello.
Yes, somebody.
I think you're still screen sharing.
I need to stop it. Okay, thanks.
Okay. So thank you very much there, Fatma, for that very clear overview of research of the Africa Mediation Network, and incredibly helpful to have that PowerPoint presentation, which I hope everyone will be able to have a look at afterwards. I wanted now to take, I think we've had several questions from the floor. So I'd invite your responses to those questions before we then have some more discussion. And so 3 questions there that are in the chat from Peter Awuni from Ghana is asking about the comparison between mediation and arbitration and concerned there over the swiftness of dispute resolution, which might also refer back to what Diamana was saying about cutting or untying the knot. A second question, a question from Hiro Aragaki, who I think is clocked into us on New York time, so must have got up very early this morning. He would like to know the ICC's view about the Singapore Convention, and it would also be interesting to have other participants' views on the Singapore Convention, of course. And then a question there from Bernadette in Rwanda about Bernadette Uwe-Chiesa in Rwanda. How can traditional forms of justice be integrated into modern mediation, which I think is a fascinating question there. Bernadette coming from Rwanda, where Abunzi has given an example of transforming the traditional justice system of gacaca into a more modern system of mediation. But I'd invite you all, if you would, to respond to those three questions, please. And do keep putting more questions in, please, if you're an attender at this conference. There was a question there specifically addressed as about the ICC. Would you like to start by responding to those questions, Diamana?
Sure, I'll take the lead with that one. Thank you very much, and thank you, Hiro, for joining us at such an early hour for you, if not in the middle of the night somehow. The vision of ICC with respect to the Singapore Convention obviously is that it's an interesting and positive tool. But like a lot of observers, the question is going to be how many signatories are we going to come out with, and ratification are we going to get? It is an interesting and positive tool in the sense that it obviously will allow to give more strength to the enforcement of settlement agreements concluded at the end of a mediation process. It, however, let's say the way the convention was phrased is challenging because of the reservations it allows, right? So we see some countries signing the convention, but with a reservation that effectively makes it unapplicable to the states, which defeats the purpose. So that's kind of where there's mixed feelings, I think, about the Singapore Convention. But as I said, we're more in a state of observation at this point to know how well spread it will be in a few years down the line. I don't know if my colleagues on the panel want to complement that view.
Okay, well, shall we go around then and hear views on the Singapore Convention and then perhaps come back to those other questions? Whichever order you like, please just chip in.
Michael, can I go first?
Yes, please.
Like I said, Michael, Zambia is landlocked and most of its nationals are involved in cross-border trade. And it's basically a trading nation, and even some of our neighbors are also basically in cross-border trading. And the number of disputes that arise in those transactions, I think, would benefit a lot from the Singapore Convention, given the amicable nature of mediation, which is a more preferred dispute resolution mechanism. And I dare say that these particular traders are not that well off in terms of finance. Arbitration would be rather expensive for them, given the fees that go to the arbitrator. That's just the point I thought I should make. Thanks.
Mariana, what about your views on the Singapore Convention?
Thank you very much, Michael. I truly think that it's a really critical tool to promote mediation in a certain type of disputes. I would say not for disputes that are, of course, domestic disputes, like the ones that I was referring, like labor disputes. And even, I think when we address the issue of how to promote mediation, we have to first think what kind of disputes mediation we want to promote, mediation to what kind of disputes, because it's very different. And this goes also to a question regarding how to introduce modern mediation into traditional forms of justice, because I think it's very different when you are thinking about mediation of international commercial disputes. And of course, the ICC is suited for those kind of cases because it's their business, it's what they do. But when we are referring, for instance, for labor disputes or family disputes, or more domestic-based disputes, I think the type of process and even the training of mediators may differ. So I think regarding your question, and the Singapore Convention, of course, is a very important instrument for commercial disputes and international commercial disputes. And as I'm aware of, in Europe, we are still waiting for a common position of the European Union regarding the ratification of the convention. But I believe that it can have the same role as the New York Convention had regarding arbitral awards and regarding arbitration. So of course, I'm really favor in adopting the convention, and I think it's useful for those kind of cases. But when we are addressing other kind of cases, maybe it's not so important, or it's not going to make the difference. It's not going to change the culture of the people, I would say. So that would be my view.
Fatma, would you like to come in there?
Yes, please. So for me, the Singapore Convention is an interesting instrument insofar as it can make it a race to improve domestic mediation laws. I personally find the convention a very important tool for marketing mediation, because people always fear the idea of the enforceability of the settlement agreement, even though in most cases there has been research has shown that mediation agreements are self-executory, but people still are afraid, and this is very understandable. So having this instrument can ease and calm the fears. But for countries to ratify it, they would need to improve their legislation, because they cannot attract the international if the local isn't working. So in that regard, I think the Singapore Convention can be very useful.
Thank you. And would you like to come in, Kenfack, and perhaps, as well as addressing the Singapore Convention, if you could also move on to those other two questions as well, of looking about the extent to which traditional forms of dispute resolution are shaping mediation in Africa. And thank you. Sorry, and the contrast between mediation and arbitration, which is more suitable for resolving various kinds of disputes in your experience?
So, first, concerning the Singapore Convention, let me tell you that I was the Cameroonian negotiator for this convention. So, when I was sent there to negotiate on behalf of Cameroon, the Uniform Act on Mediation was already adopted by the OHADA Council of Ministers. And what I have indicated during my presentation is that agreement concluded by the parties without the assistance of a mediator or a conciliator are also admitted within the context of the OHADA Uniform Act on Mediation. And we tried during the negotiation of the Singapore Convention to include this kind of agreement within the framework of the Singapore Convention. And we understood that the main purpose of this Convention is to promote mediation. But we are very thankful to the other delegation that were there to negotiate this convention, because there was a general agreement of the fact that we will not include in the Singapore Convention the agreement concluded by the parties without the assistance of a mediator or a conciliator. Nevertheless, in the 2020 ancestral model law on conciliation, you see you have a footnote 5 indicating that those states conceiving a regulation on mediation may, if they so need or if they so wish, include agreement concluded by the parties without the assistance of a mediator in the framework of the regulation on mediation. So to us, this was something very important. But that said, having contributed to the elaboration of this convention, we are of the opinion that, and somebody, I think it's Mariana who has stressed it, we think that in some few years, the Singapore Convention will be to mediation what the New York Convention is for mediation now, for arbitration, I mean. So we fully agree, and if Cameroon is not yet signatory to this convention, I can assure you that in Cameroon, the adoption process is underway. Now, coming to your question, African mediation, we usually say that African are favorable to mediation because there is an opinion according to which, and this is in Africa, if you find people in dispute, it means they had had no discussion, which means that mediation is something which is natural for Africans, to my humble opinion. Africans are usually available to mediate because when there is a dispute, they will first try to settle this dispute amicably. You see, they won't be, how can I say it? They won't be ready to take the dispute directly before a court. They will try by themselves to see how to mediate, how to reach an amicable settlement of the dispute, and failing which they will be obliged to go to the court. So to me, I think mediation is something that can be very successful in Africa because by nature, Africans are available for mediation. I don't know whether I am answering to your question, but I now see a question from Hero. Do you allow me to answer to this question, Michael?
Yes, please do. And then I think Diamana had her hand up. And then I wonder if we could run the poll before giving people a couple of minutes for their closing comments, because I know that we need to finish promptly at 1:30 in Moroccan time.
Okay, thank you. The hero's question. Is there any data about the impact of the Uniform Act on mediation on the actual use of that Uniform Act? No, for now, to be sincere, I think we are still in a state of promotion because the Uniform Act was adopted in 2017. And I think even though I have said that by nature, Africans are available to mediate. The uniform on mediation is still new, is something new, which needs to be promoted, you see. And therefore, I think education at university must focus also on mediation as an instrument for the settlement of dispute, be they commercial or investment ground. And Diamana, during his statement, Diamana has stressed the flexibility and the fact that it is not as expensive, you see, as arbitration might be. Mediation is something very flexible and very cheap, you see, for the parties. And just to my humble opinion, just for these two reasons, mediation is something that could be advised and promoted, and it will be very important for African parties, because now many African parties are facing many arbitration proceedings. And we know even if arbitration is very adaptable for the settlement of dispute, it remains somehow expensive. And if you can make a comparison between arbitration and mediation, I will be in favor of promoting mediation, particularly taking into consideration the fact that now we have a regulation in which a provision indicates how to implement a mediation agreement. So I think for this reason, mediation is something important to be promoted. This is what I can say for now.
Thank you. Would you like to come in there, Diamana, and perhaps both make the contribution you wanted to and then offer some summing up comments, and we'll go around and have an opportunity for everyone to draw the threads of this discussion together. Thank you.
Yes, thank you, Michael. And if you allow me, I'll just also touch on two very brief questions that we have in the Q&A box, because I've noticed we've had questions both in the discussion and in the Q&A box. So just to complement Gaston's answer on, the articulation between arbitration and mediation, being at the ICC's director for both and all our dispute resolution services for Africa, as I was saying, we see in Africa a strong case for mediation. That being said, I don't want to mislead our audience. The reality is that certain types of disputes, not because of the business sector involved or the amounts at stake, but rather because of a number of I would say the sort of emotional environment of the case. Certain disputes are not, I would say, resolvable by way of mediation. That being said, what my proposal is, rather than arbitration and mediation should be complementary, and arbitration in the best case scenario, especially for parties which have, let's say, from a statistical perspective, less chances in a favorable outcome in arbitration, there is a case for systematically going through mediation, which would allow for, as I was saying, a more the word is escaping me, but a solution that would be easier to accept and better negotiated, because the party would have taken active part in designing that solution to the dispute at stake. So my proposal is rather a complement for those two methods to be used one after the other, starting with mediation, rather than saying mediation should completely replace arbitration or vice versa. Now, very briefly, going through a couple of questions that were put to me in the Q&A box. The first one is whether, is the question of how many ICC mediation cases are self-standing as opposed to the mediations that are conducted in the context of an ICC proceedings, arbitration proceeding. The vast majority of our ICC mediation cases that are handled by the International Center for ADR are self-standing cases, mediation cases, apologies. I don't have the exact figure, but I can come back to Giselle, who is putting that question to me. But the vast majority of cases are self-standing. That being said, it is true that our arbitration and mediation rules allow for parties to agree on having a mediation either before or during an ongoing arbitration. And we do see a number of cases where that happens. And it's an interesting thing to observe. The second question that was put to me by Professor Walid Ben Hamida is whether from ICC experience, which in ICC experience is the region of the world where mediation works the best. We have very interesting results in Latin America. And I want to mention the case of Latin America also because we do have those very interesting results with mediation cases touching on disputes involving states, Latin American states, right? Extremely big projects, complex projects in which we see parties reaching a settlement agreement with the help of an ICC neutral facilitator. And I would say, I mean, although most of our parties come from Europe, the result of our Latin American cases are quite interesting. Now, as to my final words, Michael, and I'll stop there. I do believe, as I said, that there is a lot of room for fostering a mediation culture, starting with the young minds. I'm a true believer in the youth, and I agree with Gaston Kenfack when he says that mediation is not just foreign to African culture, but it actually is an integral part of African culture through family mediation, also tribe mediations. And as Fatma was saying, there's a lot of literature about that. And because of that, I do believe that there is a strong case for African states to promote more actively mediation and themselves use mediation in those cases where they are potential parties to a dispute.
Thank you. Are you happy to come in there now, Mariana?
Thank you very much. Thank you very much. I'm going to be very, very brief, just to say that for me, it's obvious, and this conference and the speakers have shown that mediation is kind of gaining momentum in Africa and in different jurisdictions. From the point of view of Angola and Mozambique, which is were the countries that I brought to you today, this is pretty clear in the sense that the state has understood that this may be a very good solution for dispute resolution and for maybe to gain peace between citizens. And the point here that I would like to highlight is that maybe the right place for mediation is precisely between those traditional means of justice that we were just discussing and try to understand them, and mediation, what mediation was kind of feature, well, by, I would say, starting in the United States and then UK and just afterwards continental Europe. But I think that each country has to adapt and adopt and then adapt mediation taking into consideration its own specific culture and its people, and how people see conflicts, how they address conflicts, and what is the proper way to do that. Because probably, and I'm speaking for, again, Angola and Mozambique, the traditional court system that was a system in these countries that still come from the period before independence of these countries are tailored by some European models that maybe are not very suited for those countries, or not in all aspects. So I would say that the key for mediation is to find its place between these two different approaches. And the example of Mozambique, getting back to the example of Mozambique, it's maybe a clue for that, because they have enacted a law that for traditional courts ruled unconstitutional, but the people still resort to it and use it in a very high scale. So maybe there's room there to fix the exact model that will suit better the country. Thank you very much again for having me here today.
Thank you very much, Mariana. Kenfack, would you be willing to share your closing comments?
Yeah, Michael, thank you. I wish to congratulate Emilia and SOAS as a whole for having this very important initiative concerning mediation. And I fully share Diamana's view, according to which mediation and arbitration have complementarity. There is a complementarity between the two. You see, generally speaking, the provisions concerning the settlement of dispute in contract provide first mediation, failing which you can go to arbitration, which stress this complementarity. That said, depending on the nature of some dispute, mediation or arbitration might be more accurate. My final word will so be to say, now, concerning the OHADA area, we have a uniform act on mediation. And with this, we are in conformity with the international community that promotes mediation as a tool for the settlement of commercial or investment dispute. So I am in favor of such initiative to promote mediation, because it's also an important tool for the settlement of dispute. Thank you, Michael.
Thank you very much, Kenfack. Fatma, would you like to share your closing reflections with us, please?
Yes, thank you, Michael. So my reflections is we need to continue the study, not only the African network, but all African states, because we cannot change what we do not know. For example, we've seen in Mozambique, people like mandatory mediation, even if it was ruled unconstitutional. I read in an article that in Ghana, when there was compulsory mediation, people didn't like it just because they felt compelled to go, even if they like mediation outside the compulsory system. So there are very variants of cultural differences across countries and across programs. So we need to understand what ticks and what doesn't tick, what works, what doesn't work. And there is not one size fit all. Mediation can fit any type of dispute, but we need to be very flexible with the style. We need to study the different styles, what work, what doesn't work. And there was a question in the panel about mediation in criminal matters. It definitely works. And there are also other modalities like restorative justice that is used in criminal and in civil matters. So I think mediation is there to work. It needs to be backed up by the country, by the government, for it to be successful. And I would conclude by saying, just let's keep studying what's in there. Thank you.
Thank you so much, Fatma. It's been a privilege and a pleasure to be with all of you this morning. And I'm going to leave it to Nigel to kind of offer a final comment on drawing some of those threads together. But I just want to say how amazing it's been that we haven't just talked about COVID. It's been such a pleasure to be with you all. My only regret is we haven't had an opportunity to hear more from people from the floor. And I hope that in a future conference, when we're meeting face to face, we will have. that opportunity. Thank you, Nigel.
Thank you, Michael. Just to agree with the other previous speakers that the two processes, arbitration and mediation, do complement each other. However, speaking from the Zambian perspective, one can speak more to mediation than arbitration, because we've gotten to a stage in the recent past where arbitration is more or less mimicking the court procedure and litigation, such that it's becoming less popular than it was when I was a young man just starting out as a legal practitioner. You have battle lines drawn between the various counsel and the parties. You also have the usual delaying tactics that we see in the court system, also perverting the arbitral situation. So Zambia, the amicable nature of mediation is making it more and more popular, and the fact that it's not being corrupted by litigation makes it even more popular. Thank you, Michael, once again. Thanks a lot.
Thank you all, and for being so well disciplined in your timekeeping. Amelia, can I, and thank you, Amelia, for making this possible today. Can I give the final word to you, please?
Thank you so very much, Michael. Thank you, Mariana. Thank you, Nigel, Fatma, and my very, very dear Gaston. Thank you, and of course, Diamana. Thank you so very much for your panel. It was your group that put it together. A couple of things that you've said which resonate with me before I tell you your results. So don't worry, you haven't failed, but I'll tell you your results. A couple of things that come through is the work that the mediation group needs to do. And you've already started doing that work, which is this comparative nature of your panel, helping us understand what is going on in different parts of the continent. I want to, we're here to support the group as best we can. We will make our platform available, which we're doing, and you will continue to have your own special panel at any of our conferences. We're very much looking forward to in-person events again, and that will be important, because one of the things for your group to consider is whether you want to have maybe a side half-a-day training thing for people, for us, for those attending conferences, so that they can understand and see how mediation works in practice. So that's something that I know I've been discussing with Hiro and Michael, and that's something we do need to take forward. Our keynote speaker talked about the lack of research as it relates to the Africa Continental Free Trade Area Agreement from Africans, from African academics, researchers, and writers. I think this is another area wherein we do need some indigenous research coming through and publication. And you are already, the report from your research is already doing that. We need more of that, because that feeds back into our understanding of what is actually happening globally. I would always say that mediation, arbitration, none of that is new to the continent. We had different terminologies for all of these sort of processes. But as long as you're more than yourself, so you have another person, any couple will tell you, there's bound to be disputes. And so we sort of, as human beings, find a way to resolve those disputes. So it's just to say a massive thank you. Now I know you're all itching to know what your result is. Okay, great. So let me tell you and put you out of your miseries. So the first question is that the speakers clearly address the topics. Michael will not give any of his students 100%, neither will Fatma or Gaston, but you all got 100%. I'm sure Diamana doesn't give 100%, but you got 100%, which is great, and it's consistent. The second question, were the topics useful for your practice, education? of course you will get 100% because all your members are on the or attending the panel. So you also got 100%. The third question, should African states use mediation in the resolution of their investment disputes? You do have a large following because you got 95%. One person, and I suspect that person must be a major arbitration person, said no, but every other person said yes, so that's 95%. The fourth question, should African states ratify the Singapore Mediation Convention? You'll be very pleased to note that 95% said yes and 5% said no. And so there's some work to be done there. Maybe we do need to have a clearer understanding of what the Singapore Mediation Convention is all about and objectively how it might impact on African states to enable that knowledge sharing. So thank you very, very much to your panel. It's been a pleasure, and I'm sure we will see all of you again at our conferences. So the next thing on our own on the agenda is for us to go and eat lunch. Yesterday, I said that if we were in Casablanca, remember we're meant to be in Casablanca, we would be eating couscous. And there is no better place to eat couscous than in Morocco. I mean, that is amazing food. And so it wouldn't be fair for me to say eat couscous yesterday. And today, again, I'm asking you to eat couscous. So eat something else. But enjoy lunch. We're going to restart with the last panel at 3 p.m. Casablanca time. So that will be almost in an hour, 30 minutes time. And so you will need to join that panel via the link for that panel. I'm going to be speaking on that panel. So all you mediation enthusiasts, come, because we want to follow through with what you've said to us at this panel. And we're going to be looking at dispute avoidance. We think on our panel, we want to share how we think that African states can avoid disputes in the first place. And so you've said, well, leave these adjudicatory processes, go for a more conciliatory mediation process. And we're saying, don't even find yourself there at all. Save this $20,000 that Diamana mentioned as the average cost for ICC mediations. So we look forward to seeing you in another hour, 30 minutes after lunch. We will start on the dot of 3 p.m. Casablanca time. Thank you very, very much. See you. Bye.